Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How period does the FBI find people? The people is misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
I object.
What more do you see? Because he's the guy.
Alrighty, there's the mute button. All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. Great to have you joining here with us this afternoon. It's a busy day. If I hold my shirt like this, it looks like it was ironed, sort of. That looks so bad. Oh, man. Wearing the shorts today, I don't want to do the foot reveal, but we'll do the calf muscle. How about that? Is that, there we go. That's it. All right, that's enough. Welcome. Good to have you back. Looks like the seats just got turned on. Everyone's taking a seat. Wonderful. Thank you. Appreciate that. Down in front. There we go. Welcome back. We are just a few minutes away from joining up with the Karen Reed hearing, which is going to be starting here in just a minute. We're going to take that live when that happens. Spicy goodness coming your way soon. But first, we have to say, Greeners, congratulations yet again. Habitual offender at this point. First in chat, congratulations. The internet is all yours, my friend. Keep it running for the rest of us. We will not complain. It's a no pants Friday. I've got shorts on. I count shorts as not pants. So I'm just chilling. It's 70 degrees here. 70 degrees. It's beautiful outside. It's the wind's blowing a little bit, starting to clear out the air. I can start to see the definition of the trees up on the mountains, way over the landscape there. But beautiful day here in northern Utah, where I'm at an Airbnb, home away from home. This is the studio. I'm not home. So love it. It's all working. Still have to make some changes. The TV is fixed on the wall. I can't move that. But I like to watch that, and that means I'm looking off the screen instead of looking at you. Normally, I run my camera almost in front of my TV, so it looks like I'm looking right there. So I've got to figure out either move this or something. I don't know. Maybe I'll just live with it for a month. It's only a month, right? All right, let's see. We need to thank Kiki's Garden. Kiki's Garden. By the way, if you don't follow Kiki's Garden, you should on YouTube. She puts out wonderful little videos about plants, and what's better than that? Congratulations, Kiki's Garden, on the great YouTube channel, as well as gifting a membership. Thank you for your generosity this morning, afternoon. I think it's still morning for me. Half an hour of morning for me, and then it will be afternoon. Sean White says, are we covering the Karen Reed stream? Yes, you are covering the Karen Reed hearing. It starts in roughly 10 minutes. We should have a feed about then. So as soon as we get video from that, we're going to go ahead and bring that to you live. Kids are sightseeing, seeing friends, seeing family, doing all that. Let's see. It's a super nice place. Yes, we can only afford it for a month. This is not a place I could afford to live, for sure. But I come from a pretty good-sized family, and we've got a family reunion scheduled for next year. And oh my goodness, did they pick a spot? Wow, it's gorgeous. It's gorgeous. So I have to start saving so I can afford to go. But it's beautiful. Anyway, Catherine, no notification. No, but at least you're here. That's all that matters. As far as Judge Boyd goes, they might. I think the jury likes the free food. They are still deliberating. They cannot come up with a sentence. I'm going to be gone for a month. Why did I think a week? A month and a week or two. So it's like a month and a half. But yeah. The family's going to be having fun, vacationing. They're going to the pool, everything. I work the entire time. So, Judy, it's 108 where you are? My goodness. That's really hot. Hey, Siri, how hot is it outside? 87. 87 here. That's livable for sure. Definitely livable. I can do 87. I had my eye on the park. I might go over to the park here this afternoon. Where are we vacationing? Utah and Idaho. We're going to be going between southern Utah, northern Utah, and up through the middle of Idaho, and seeing sites all over the place. I don't think we're going as far as Yellowstone. I don't think we're going to go there this trip. We have gone previously. That's one of the only other places our family has ever been on vacation, and we went there for almost a week. We were only in the park for like 2 days. All right, sound set for this. Reset there. We're all good. Does it make sense if is this too confusing if I have all my pictures here and then I just have like program out up there? Let me unplug everything right during the middle. Oh no, I can actually do it digitally. See, outputs, output 1, multi-view, output 2, multi-view. Let's do program to this one. They now have program out right here. That's what you guys see, which is sort of weird. I don't like that. Let's do multi-view there. And that way I can control this little one right here. Yeah, this is good. This is good. All right. Let's see. Allie B from Tennessee. There are like 4 channels I want to watch on this. Yes, I can only watch 3. Not enough devices. That's the problem, Lisa. Or Allie. Sorry, Lisa's down here. Are we staying in the Airbnb the whole time we're in Utah? Yes. This is our home base. We're miles from anybody we know or related to. It's funny because we designated this as like the middle ground. Like I've got family in Texas, and we came here and met here because we don't want to come all the way to each other's state. But apparently Utah was the middle ground for that. But we got to meet up with them here, which is really cool. Let's see, still nothing on court. We've got audio turned on so that when that happens, it comes in. Chris Wallace gifted a membership this afternoon. Thank you very much, Chris. Sherry Smith was the recipient. Congratulations, Sherry. Boys and their toys, you're having too much fun. I am. I really am. And I own up. I admit to that. Megan says you're like 15 minutes away from me. Okay, I could not. I'm used to North Carolina, right? And I happen to live in a part of North Carolina in Pitt County where you're an hour and a half from anything. Anything you want to go do, whether it's to Raleigh, whether it's to the beach or anything, everything is an hour and a half away. And I've just come to expect that if you want to go do something or go somewhere, it's at least an hour and a half. And then I came here and I'm like downtown Salt Lake. And I'm trying to head to a destination. They're like, oh, you'll be there in 9 minutes. And I'm like, that's a county away. No, it's not. It's only 9 minutes away. 15 minutes away tops. It was nuts. The distances are crazy. Are we still getting Karen Reed stuff? Yes, you are. This is going to be the juicy one. This is going to be really, really juicy. In about 5 minutes or so, we expect a stream, the feed of availability to come in. What's the difference between tornado watch and tornado warning? Weather watch? Are you here? We got both of them. And I've been seeing pictures on our Facebook feed from our hometown of just houses flooded. I'm just trying not to think about it. I'm trying not to think about the fact that if mine's flooded, it will, could be a month before I find out about it, which is a bad situation. All right. Let's see. Kathy upgraded to jury. Kathy, congratulations. You get a padded seat. That's one of the perks of jury membership. A padded virtual seat for all court watching. Philadelphia tornadoes. Greeners, good thing you brought your family and equipment. I brought my entire studio. The only thing I did not bring, there is one computer left at home, an old one. It's the one I normally use for chat. And I did not bring any of my portable audio kit for wireless mics. And there's like one audio board, like a a mixer, which is it's a cheap mix. It's like a $150 mixer. That's cheap for mixers, an audio mixer. So those were the only things I left. Every other piece of equipment I brought with me. So if the house floods, I can just set up somewhere else and be good. The digital audio stuff, the digital audio wireless mics and everything, I left that at a friend's house. So now it's safe there. So it's not in danger either. How do you upgrade membership? I think we'll have to ask Kathy. Kathy, how did you upgrade your membership to jury status? Do tell. I don't know how to do it. Maybe she might help us out. All right. Just too much rain. It's been a ton. The sound effects, the computer that does chat also does sound effects. And so we don't have sound effects yet. I have all the commands, but I just need to point them to files. So if you have a sample file that's not like something Disney will sue me over, that you'd like me to use for a sound effect, and if you can send it to the burner phone, I might be able to temporarily reassign all our favorite commands with sounds. So like the buffer sound, instead of being the dial-up, AOL internet sound, now it's like, job's done. And because that's the only sound I had on my computer. That's the only one. And I left my yes, no signs. Yes, I left those. Is your house at risk of flooding currently? The news reached out to me and said they would pay me to show video of the flash flood in my area. So I think it's a risk. If you go to the RA homepage and then tap to see perks, there's an option to upgrade there. Well, there you go. Samantha, thank you very much. Appreciate that. Gas money or treat fund? It might be gas money the way things are going. Thank you, Nurse for God. I appreciate your generosity and your support of the channel. Let's see, 2 minutes till pumpkin time for Karen Reed. That's going to be where we're going first. Once that is over, we're going to do some reading from the Young Thug trial. We've got some new documents that dropped just a little bit ago that we're going to go there. We are covering Karen Reed. That's going to be first. And that's going to be live coverage. And then we're going to go to a readathon. But it's just going to be me, because I didn't set it up the other way. My head is messed up. This time frame thing is just not working. Ivy, do we have a new switcher yet? No. And so when you see me keep playing with cables and unplugging and replugging things, it's because I found a workaround where when the audio drops out, if I unplug it and replug it back in, it will work for a little while. And so that's our solution for now. We do have one scheduled to be purchased. The way that YouTube works with money, and you guys were super generous with funds to help pay for a new switcher. The way it works is it arrives to me on the 21st of the following month. So mid this month, we can get the new switcher. Kenda Ducote, is it Ducote or Ducote? Upgraded membership to jury. Thank you very much, Kenda. Congratulations. Nurse for God, you figured it out as well. Also upgraded to jury. Thank you very much, both of you. Now in the cushy seats. No hard bench for you, members of the jury. Thank you very much. All right. We're just waiting for a feed, and we'll bring it to you as soon as we can. Let me get this set up. I need to manually build the crop because I can't get this. Still having network problems, so we'll get that fixed here shortly. And let's put that one there. We'll get that fixed because it does all my adjusting sizes in video. Does anyone think Beverly would dismiss? I think there's a good chance of it. I really think there is. It's a possibility. Nurse says, I love my padded seat. I also am sitting on a padded seat. Just for the record, I am sitting on a turquoise silk memory foam pillow, because this chair is the least comfortable chair I've ever sat on in my life. All right. We have, I think, 15 minutes before, or 17 minutes before the hearing actually starts. So any minute now we'll get our video feed. Do a poll. Poll on whether or not will the judge dismiss. Is that the poll you want? Man, this is weird. I've got. Oh, and I just checked on Trial TV Live, and he's up to like 1.1K on their channel. That is awesome. That's really cool. Thank you, everyone who went over and given us support there. All right. If I go live on this one, let's turn that off. What were we asking for? A poll? Tumwater Troy, welcome to the jury. Welcome to the jury, Tumwater Troy. Appreciate your support. Upgrade there. Cushy seats are going quick. I hope there's no limit to how many people we can have on the jury at once. Okay, I'm writing the question here for the. Hang on, I'm clicking on the wrong screen. Ivy Berlin, don't feel bad. Do not feel bad. What I do for work is what I do for fun. So honestly, yes, I'm working, but at the same time, if it wasn't work, I would still be doing it. I love what I do. I will have plenty of time to play and hang out, and we'll get that done as well. Okay. Will the judge dismiss counts 1 and 3? That's going to be the question for the poll. Oops, if I can type it correctly. Counts 1 and 3 are the two that the jury agreed on. I'm going to add one more option. We've got a yes and no, and we've also got no decision today. If I spelled that right. Let's start that poll. All right, so the poll is up. You can choose whether or not the judge is going to dismiss counts 1 and 3 against Karen Reed, or if there's going to be no decision. Does that mean this trip is going to be able to be counted as a business expense? No, Genjo. I've actually I had that question as well. There are very limited things that I can write off as a business expense. We're very, very careful on that because the one person or the one organization you do not want to tick off is the IRS. So we found an accountant that's really, really helpful that way, and we run things by her. And she made it very clear that you don't want to blur the lines when you've got a dual purpose event like family vacation and business trip. Don't call it a straight business trip. Although I can do such things like take Mrs. R.A. out to dinner and legitimately talk about the company, about business, about how finance stuff, decisions, upgrades, things like that, and that can be a business expense. That's legitimate as long as we talk about that. But we don't do that very often because that would look bad if we did like 4 business meetings a week. That would be bad. Live on the edge, man. Nope, not when it comes to the IRS. That they don't play games. They carry guns and take money, and that's you don't want to get them mad at you. All right. Try Live TV is the name Aaron? Is it boy Aaron or girl Aaron? I don't know. Just don't Try Live TV. Oh, guess what we have, guys? It's back. It's back. We've got the fan. It's our only fan. The courtroom looks awful. Yeah, we're gonna do stereo. That's much better. Okay, we've missed you. The camera knew we wanted it. I'm going to turn the audio down just a little bit. It's our biggest fan. We're ready for the hear ye, hear ye. All persons having business before the Superior Court in Dedham, please, make yourself heard. Yeah, whatever. It's the only fan, Ceiling Dion. Ceiling Dion. fact the fan is not... The reason why fan is not wobbling is because it's been properly balanced. Most fans wobble. They do need balancing, just like your car tires, believe it or not. This is the only fan emoji. Maybe we need a fan emoji. There's some dueling demonstrations outside the courthouse. Imagine so. She answered me. Let's see, who was I asking a question of? Oh. Yes, I did. Girl Aaron, boy is Aaron. Thanks for clarifying that. I appreciate that, Trail Live TV. I won't call you he anymore if that's what you prefer. So, love your channel. Glad we could help you out in a little way. Looking forward to great things from your channel as well. And welcome to YouTube, by the way. It's exciting. I mean, you've been here for a while, but welcome. Yeah, boys is AA Ron. Right, I've watched that as well. Lots of pink shirts outside the courtroom. When's the next Canton Town Hall? Kaylee, the Canton Select Board has been meeting virtually. Not because they have to, but because they can. And by meeting virtually, it makes it so they can't have interruptions, because you get to literally just mute the person if they're talking and you don't like it. And so they've switched to Zoom indefinitely. And so we'll wait and see when they go back to actual in-person hearings. But I'm not expecting much from them. Done it my entire life, being born in the 70s. No one had a clue. I was also born in the 70s, Aaron. Wonderful. 77 was for me. Canton Town Hall, I think it's Tuesdays and Thursdays. I'll have to check the schedule, see when their next one is. Hopefully it's in person. Let's see. You were named after the actress that played Tabitha on Bewitched? Is that the one where she twitches her nose and makes things happen? Johnny Thunders, have I missed the sentencing on the 90-mile-per-hour killer? That's Judge Boyd's courtroom. I think they're still deliberating. We might miss it because we're gonna stick with Karen Reed here. But if it does come in during the Karen Reed hearing, we'll go back and watch that for the sentencing. I'm just a baby. I'm just a baby. I feel young. I always tried to wiggle my nose when I was young. That's a skill. That was not CG. I mean, that was legitimate. Graduated in 1977. It was a good year. It was a good year. AZ DCS oversight. They brought in a couple ringers, I think, in the last one, Josh. Brandy's like, if I could just wiggle my nose, I know I have powers. Kendra's like, my husband's named after Darren from the same show. That's funny. We've got a few minutes here. We expect, as long as the judge is on time, for her to be starting in about 8 minutes. So we'll get a little bit of some courtroom noise until then. Ooh, ooh, ooh. There we go. Counsel's present. Mr. Yannetti is there. I think Jackson's probably going to be in. I think Jackson's going to be on Zoom. Nothing like putting your belt on national TV. Bailiffs are doing their pre-hearing warm-up. Got to warm up the pipes for the hear ye, hear ye. Get set. I think it's just going to be. I don't think Jackson's going to be here on this one. A few different people on the media pool. Some new faces. See the flip-top water bottle. That's nice. Karen gets a notepad. It's interesting. Going back to the poll, we're going to go ahead and close out the poll today. I think you're correct, and I think some of you might have cheated and paid attention during the last hearing where we heard that the judge is not in a rush to make decisions. But we're going to end the poll right now. Looks like as far as the count goes, no decision today is the winner with 47%. 30% said no. Yes said 22%. She is going to dismiss. So just less than a quarter of us think that it's going to be dismissed. YouTube, of course, stole one vote. Water looks delicious. Karen has Canada Dry. Is that like seltzer water? Does Canada Dry make just regular water?
You're pushing it live? We're sending it out to the other station. We're sending it out over Saturday. Okay. But I don't think we're broadcasting. We're just, we are feeding it out. I'm sure some people take that feed and put it up on the website. Some people haven't said anything. But we're in full on right now the next couple days, so.
It's a clear beverage.
I know. Bro, that's interrupt a lot of things. Absolutely cannot interrupt you on this. That's gonna. Wow. I was gonna say now, what'd you get for this work? Fantastic. Is that archery? The firearms? Just. Now is that air or are you using
All right, it's boring courtroom audio. Ooh, what's that? Somebody got a card? What a nice card. Give him a nice card. I'm going to mute the audio here, just turn it down a little bit. Wish they were drinking out of solo cups. Oh, that would be epic. They walk in with their solo cups and pour water in. I think the judge would flip over that, though. We're back in, this is the regular courtroom. This is the same courtroom we had the original trial in. The previous hearing was in a different courtroom, a little bit different layout. Robert Tellis trial starts Monday with jury selection, I believe. Not sure if we're going to get to see any of that. That's out of Las Vegas. But once it starts going, it's going to be good. This is a crazy courtroom layout. I've never seen one like it, with the prosecution in front and defense in back. It's a very tight courtroom, very limited space. Like size-wise, it's tiny, especially for a case of this notoriety of this many people wanting to participate. We have family coming in, taking a seat there. I forget who the closest lawyer is. I think it's just, I don't know if he's from Yanetti's firm or Jackson's firm, but there we go. Brother is here. He's never missed a single date in court. And that seat is reserved for him. Everybody knows that's where he sits. He finally spoke out after the court case was over and had some pretty strong things to say. Yannetti is guzzling his clear beverage. Media pool is in back of the family. They sit in back there on that at the high tops. The media pool sits at the high tops. Should be calling order here in just a moment. Mathis says probably all lawyers, local lawyers from Mass. Zachary Wells just gifted another 5 memberships. Congratulations to the lucky recipients. All good people. Thank you, Zachary Wells. Appreciate your support. Karen's wearing blue, which is interesting because that's what the people are wearing for the Justice for John O'Keefe outside or for Justice for JJ, right? Outside the courtroom. Those windows are really bright. We've got sunlight coming in, causes it to be backlit. Here we go.
Hear ye, hear ye, hear ye, all parties having anything to do before the Honorable First Justice Beverly Canoni, now sitting in the Norfolk Superior Court within the Fuller County and Norfolk, Rodney, and your defendant shall be heard. God save the Commonwealth and the Court, and the seat court now set.
Judge 22117, the Commonwealth versus Karen Reed. So identify yourself, starting with the Commonwealth.
I'm not the Commonwealth, Captain.
Good afternoon, Mr. Manley. Good afternoon, Your Honor, Laura Butler. Good afternoon, Mr. Butler.
Good afternoon, Your Honor, Ron Weinberg, on behalf of Karen Reed, who sits to my left, and co-counsel David Dean.
Good afternoon, Mr. Weinberg. Good afternoon, Mr. Manley. Good afternoon, Mr. All right, Mr. Weinberg, I will hear you on your motion.
Thank you, Your Honor. May I use the podium?
Of course.
Thank you.
Hope it has a mic. There we go.
Judge, there are 2 central issues.
Don't know if there's a microphone there.
There's not one for amplification, but there's one for recording.
If I could ask you to keep your voice up and turn off the air conditioner, please.
Yes, Your Honor.
I just want to make sure I hear it.
On a day like this,
She's already turned off the AC.
Thank you, Your Honor. There were 2 central issues that are raised by the motion to dismiss and the supplemental affidavits that have been filed on behalf of Ms. Reed. The first of them is whether or not there's strong and I contend uncontradicted evidence that the jury reached a unanimous decision, even if it wasn't formalized into a vote or into a polling announcement to the court. But it's strong and uncontradicted as a result of the juror declarations that were made through counsel to the court, sworn to by counsel, that the jury reached a unanimous verdict on 2 of the 3 counts of the 3-count indictment. So the legal issue is in the face of that evidence, whether or not Ms. Reed can again be re-prosecuted for the same offense by the same prosecutor who we contend failed to prove her guilt to even 1, much less 12 jurors in trial 1. And when I address that, Judge, I will make a proposal to Your Honor that's close to the procedural pathway used by other judges in cases similar to this, in terms of just how do we transform representations in attorney affidavits into hard proof that we believe will convince the court and in fact will lead It will convince Mr. Lally and the District Attorney's Office that that jury, the jury that Your Honor described as an extraordinary jury, reached a decision. It will be consistent with their jury service and consistent with respecting that jury service that we give at least the jurors who are willing to appear before the court anonymously the opportunity to inform the court that this was a final unanimous decision. It didn't get further deliberation. It was a unanimous decision on 2 of the 3 counts, and the impasse was in fact on the 3rd count, which was count 2, and the lesser included the manslaughter count. The second of the legal issues that I want to address, and they both together center on the double jeopardy clause, its unique history, and it's discouraging, if not deterring, if not prohibiting, second trials when there's any rationale that would justify the verdict of the first trial, the first jury, or the continuation of the first jury's deliberations, is whether or not, now that we have evidence that the jury was not at an impasse, evidence that was not known to Your Honor at the time that you ordered that they be disbanded and ordered the mistrial, evidence not known to Mr. Lally and the prosecution or the defense, that in fact the note they wrote to Your Honor after the Toohey charge on July 1 was not unambiguous, as Mr. Lally wrote in his pleading. It was ambiguous. It was subject to 2 constructions. One, that their impasse covered all 3 counts and therefore would lead ineluctably to a mistrial declaration, or 2, that the impasse was on 1 count with multiple lesser included charges, but did not encompass counts 1 and 3. Your Honor didn't know what was in the jury's mind, what was in their mind when they authored a note to the court. Neither did counsel. But the issue now, and again, it's in the context of double jeopardy, which is such an historic and important clause that was enacted by our founding fathers to give them some protection against the sovereign, at that point the king, against simply choosing to mistry prosecutions that weren't going well. And the founding fathers wanted citizens not to have to face re-prosecution. They understood the ordeal and anxiety and risks of having to prove to a second jury what they had proven to a first jury, which is that they were not guilty. And so the real issue here is legally, what do we do when we now know that jurors are declaring to the court that they believed they reached a verdict of not guilty? What can we do on August 8th, if I've got the date correct, 6 weeks after the July 1 trial that Your Honor presided over, a lengthy trial with an exceptional jury? And I contend, Judge, that we can't just accept a fiction that the jury was at an impasse on all 3 counts when 4 jurors are saying to you through counsel they were not, and a 5th juror is saying to counsel indirectly they were not. We have to embrace the fact that these are now facts. Yes, they come after the end of the trial, but it doesn't mean that there's not some procedural pathway to integrate those facts into Your Honor's decision-making. And the second one, the manifest necessity issue, has got a lot more SJC and Supreme Court guidance. It's been the subject of lots of cases. We're walking a little bit down a pathway that has some precedents about jurors and they're being reconvened, but it doesn't have the clarity of the precedents regarding the manifest necessity standards, guidelines, principles that we'll address second. But here what we know is that 4 jurors reached out to defense counsel. Jurors A, B, D, and E, I think is the way they've been described by Mr. Jackson, who received calls from 3 of the jurors, and Mr. Yannetti, who received a call from 1 juror and talked to somebody who himself or herself spoke to a 5th juror. We also have the corroboration, not just internally, where these 4 jurors are essentially saying the same thing. We reached a decision. We didn't announce it. Some said we felt bad about it. We didn't know what to do. But they were internally consistent and not self-contradictory, and that makes them more trustworthy. They corroborate each other, and I contend that the voicemail left on Mr. Lally phone, which he responsibly shared with counsel and shared with the court, essentially saying this was probably one of the 4 jurors, but we don't know for sure, said essentially the same thing. We reached a decision that Ms. Reed was not guilty. Murder, the most serious charge that can be brought, a charge that would imperil the rest of her life if there was a conviction. Other jurors tried to reach the prosecutor. They didn't succeed. The prosecutor made a decision that he couldn't promise anonymity, which every juror seems to want, and that's understandable given the level of media and public attention on this case, and I understand the court gave them discretion, and Your Honor made an order that the defense didn't dispute that they were entitled to anonymity. The public interest did not weigh the interest of the jury in anonymity. But we now have the declarations of the jurors through the defense counsel. We have a voicemail of one juror through Mr. Lally. We have emails of other jurors who only wanted anonymity as a condition precedent to talking to the prosecutor. This case, because it has catalyzed so much publicity, it's plausible to believe, if not compelling to believe, that other jurors who sat through so many weeks of testimony, this was probably one of the monumental central events of their life. Not many people, certainly not people who go, other than people who go into military service, have opportunities to serve their community like these jurors did. Not one of them, to our knowledge, has picked up the phone to defense counsel and said, those jurors that you're memorializing in affidavits and in motions, I don't agree with that. No one has called the district attorney. Nobody has emailed anybody. Nobody has called Your Honor through the court clerks. Nobody disputes, in other words, none of the 7 or 8 jurors that are not, represented by the series of affidavits of defense counsel dispute the truth of the representations made by counsel. We don't have certainty. We only have the reasonable inferences from the absence of other declarations, which is that this jury was unanimous in its acquittal of Ms. Reed on counts 1 and 3. So then we get to the legal issue, and again, as I tried to say, the legal framework here, the landscape is not quite as crystal clear as it is in the standards of manifest necessity, whether or not double jeopardy permits a re-prosecution in the context of this unique case. But what we have is court decisions saying, for instance, what constitutes an acquittal is not to be controlled by the form of a judge's actions. We're not bound by labels. That's the SJC in Commonwealth versus Taylor. We have Justice Ginsburg joining Justice Sotomayor and Justice Kagan in a dissent in the Bluford case, saying, in ascertaining whether an acquittal has occurred, form is not to be exalted over substance. And they are making that point. I mean, I've done this.
That's a dissenting opinion, though.
Procedures important. Form sometimes governs. And it's the recognition that double jeopardy is different. For instance, as I'll get to in the manifest necessity phase of the argument, all of the courts put a heavy burden on the prosecutor to justify a mistrial order, to justify a re-prosecution. Ordinarily, I'm used to the burdens being on me as a defense counsel. I'm used to having an affirmative obligation to lay out for an appeals court exactly what I want. But in this unique area, the disincentive to re-prosecuting somebody, the same prosecutor for the same offense, when there's evidence of an acquittal or evidence that the jury wasn't at an impasse over all counts, is so significant, it's so core to our values, that they put the burden on the prosecutor, and I will get to the cases that support that, what I call a central proposition, which is, where's the default? Is the default from not asking the jury about these other counts that this Reed goes to trial again? Or is the default instead that the prosecution simply cannot again re-prosecute her when there was not manifest necessity in the first place for the counts 1 and 3? The Supreme Court 67 years ago, and I remember it because it was the tail end of the Warren Court, and it revolutionized criminal justice, and it talked about Miranda rights. Nobody knew Mr. Miranda back in the 1950s. Gideon gave right to counsel rights. Mapp v. Ohio extended suppression remedies for Fourth Amendment violations. These were all unknown until the Warren Court. The Warren Court, in the case of Green versus the United States, and it's in our pleadings, said, and it's important, that double jeopardy was designed to protect an individual from being subjected to the hazards of trial more than once. That the state, with all its power, should not subject a citizen to the ordeal of living in a, quote, continuing state of anxiety, as well as enhancing the possibility that even though innocent, he may be found guilty by a second jury. So what do we do in a world where we have facts not known on July 1 that are known on August 8? And we're not, this is not completely novel territory. For instance, the First Circuit, the Federal Court of Appeals, it's 11 years since the Boston Marathon bombing. And they're still dealing because of capital punishment with whether the punishment should be life or death for the Tsarnaev that was arrested and survived. And they recently, in a lengthy opinion of over 100 pages, said bring back these two jurors where we have a principled basis to question their impartiality. The SJC just 4 years ago in a case dealing with a lawyer's allegation that there had been a racial statement. It's called the McCallum case, 485 Mass 790. Said to the defense counsel, the judge will authorize you to recontact that juror and get an affidavit. And if there's any skepticism regarding the truth of the affidavit, we will have a hearing and make decisions. The nation was affixed to the Murdoch case from South Carolina, where a lawyer was accused of killing his family. And there was evidence recently, according to the media, that a clerk spoke to a juror. And the judge convened a hearing, questioned the people who were connected to it before in order to make a decision. In other words, regularly, judges who receive reliable evidence that there was extrinsic evidence, that a marshal talked to a juror, was a juror biased, was the questionnaire fair, that something happened during did the jurors access the internet when they were judicially prohibited from doing so. Courts reconvene hearings, and I can attest that it can be done anonymously. It doesn't have to ineluctably lead to the identity of jurors. And we're going to ask the court to do just that, because without in any way diminishing the centrality and the importance of an impartial jury that tells the truth on voir dire, that's not ethnically or racially biased. There's nothing more central about making sure that jury was not influenced adversely by something from the outside or even by something from the internal discussions that reflected on a juror's racial and ethnic impartiality. But why isn't an acquittal entitled to just the same kind of deference? You know, we have not evidence that the jury was not impartial or that they were influenced externally. We have hard evidence that they reached a decision. We're not asking to have any inquiry, whether by counsel or by the court, into the content of deliberations, into their reasoning, into all of those matters that are forever private. But here we're asking them no more than Your Honor could have asked by polling them, which is, did you reach a verdict on count one? What was that verdict? What about count two? No. What about count three? Yes. So there is precedent, although slightly different, but we contend no less important, to Your Honor making a decision. If Your Honor is skeptical in any way of the attorney's declarations, if you cannot accept them because they're not the sworn affidavits of lawyers, of the jurors, authorize them to do what they haven't, which is to reinitiate a call to these 4 or 5 jurors, ask them whether they would read the lawyers' affidavits and affirm that they're accurate, or alternatively authorize the lawyers to ask the jurors whether or not they would execute an affidavit that could be 2 sentences. We reached a final decision unanimously to acquit Ms. Reed of counts 1 and 3. Your Honor doesn't have to accept 4 out of 12 or 5 out of 12. Your Honor has a lot of discretion in terms of how to get to the bottom line, which is what is the truth here. Your Honor could schedule a hearing and have the 4 jurors in. They would remain anonymous. We would even waive public trial. I'm not sure the media would, but to keep this private and keep this confidential, because we don't want the jurors to, risk identity. Your Honor could do it in any number of ways. We have responsible court officers that can meet 4 jurors anywhere Your Honor selects. We have responsible lawyers and responsible prosecutors. This doesn't have to be an event that challenges the jurors' anonymity. I guess what I'm saying is that we're asking the court not through closing the door to this new evidence and really adopting a fiction that the impasse was on all 3 counts when we now know that there's strong corroborated, trustworthy evidence it was not, to establish a procedure consistent with McCulloch, consistent with Sanaif, consistent with the Supreme Court decision in Renner, and take those cases where jurors do come in after the fact, when there's credible, responsible evidence that they were either biased or that they had some extrinsic evidence, whether from the internet or from an improper contact with a third party, and help us investigate this. I don't believe that if the Norfolk DA was convinced from that process, and it could be 4 jurors, it could be 12, but if all of them tell the court, we made a final decision, we never went back like the Bluford case or to re-examine it, it was not an intermediate decision, it was a final decision. All of our impasse was about count 2 and the multiple lesser includeds. I am hopeful that the prosecution would join with us in not seeking a new trial if they were convinced by these jurors under oath to what they've not yet been convinced by, which is defense counsel. This was a hard-fought case, and I'm not being critical of the DA, but I've done this for a long time, and I believe in our system of justice. People say it's not perfect, but it's the best that the world has. This to me is hallowed ground in a courthouse named after someone who was a friend who I deeply respected. And I want the prosecutor to get the facts in the best way we can at this point in the case, which is through Your Honor. Order a hearing, Judge. Don't make Ms. Reed be the first person in the history of the Commonwealth to face re-prosecution for murder by the same prosecutor's office that tried her once and failed to persuade the jury she was guilty. They've not given a single case where facts like this have been ignored. Not a single precedent have they raised. Nationwide, state courts, murder cases, 50 states, federal, where there's been this kind of demonstration that we were silent when we shouldn't be, but she was acquitted. They've got the Commonwealth versus Juvenile, where there was a verdict slip, nobody knows when it was written. We have Bluford, but there was clearly further jury deliberation after a juror told the judge that we have reached a decision on 2 counts. I'm convinced, perhaps, through many years of doing this, that acquittals count. And if she was acquitted, nobody wants her re-prosecuted on the counts for which she's been acquitted. And form's important, procedure's important, but what's more important is substance. What's more important is to find out whether that jury, in fact, voted to acquit and it was a final vote. And then I hope there's no dispute. I hope Mr. Lally will stand up in front of you and join me in asking that those 2 charges not be re-prosecuted. So let me switch from the acquittal and its implications to manifest necessity.
Manifest necessity for mistrial.
In this case, we have explicit guidelines, which have been set out by the Supreme Judicial Court, that look to whether or not there was manifest necessity for the declaration of the mistrial. Manifest is a word that says to show clearly.
This basically is saying the judge made a mistake.
Was avoidable, whether there were any viable options, whether the court essentially had no choice, no options. And here, at minimum, with 4 or 5 jurors saying, we believed her to be innocent, and we believed there was a vote, there's no evidence from those declarations that there was an impasse on counts 1 and 3, an impasse that would have rationalized and justified the order of mistrial. The note, as I said, was believed to be unambiguous by the prosecutor, but in truth was ambiguous. It led to 1 or 2 instructions. And this is really becomes a burden of proof issue. Who bears the burden when there was an understanding by the court that the note reflected an impasse encompassing all charges, when we now know there was a rational alternative explanation for the note, a logical one, which is we were addressing only the charges in count 2, the multiple charges, the multiple decisions within the manslaughter count. Here's where the court helps us. The Supreme Court in Arizona v. Washington placed a heavy burden on the government, on the prosecutor, to justify a mistrial. The SJC has issued multiple opinions. And I'll read just a couple, because I think the burden of proof issue is central, Judge. Commonwealth versus Stewart, which goes back to 1985, and is one of the central decisions that started formulating the jurisprudence around double jeopardy and manifest necessity, says the prosecutor must shoulder the burden of justifying the mistrial if he is to avoid the double jeopardy bar. His burden is a heavy one, citing to Arizona v. Washington. Cruz v. Commonwealth, SJC 2012. The heavy burden of proving that a mistrial was due to manifest necessity lies with the Commonwealth. Commonwealth versus Nicole, 452 Mass 816, 2008. The Commonwealth is unable to satisfy its heavy burden of proving that there was manifest necessity for declaring a mistrial, and the Commonwealth is therefore barred by the principles of double jeopardy from retrying Nichols. I have a copy of the Nichols decision because it's the one that was not referenced yet for your Honor's consideration. Nichols was an interesting case. It was a driving case, jury of 6. There was belief that one of the jurors should not be sitting because he knew a witness, if I'm recalling the facts correctly. And everybody considered it and thought there was no procedure to allow a trial to continue with a jury of 5. The defense counsel thought that, and the court thought that, and the court therefore declared a mistrial. Afterward, everybody discovered that this is in fact a rule of criminal procedure, and that defendants could waive a jury of 6 just like they could waive a jury of 12. And the court determined, as I just read, that there was no manifest necessity because there was a viable option to the declaration of a mistrial, that being the court could have asked the defendant whether or not they would agree to a jury of 6, but they didn't recognize it at the time. And then the court had a decision. Are we going to blame the defendant and make them go to trial a second time in the face of double jeopardy's manifest necessity requirement? Or are we going to put the burden on the prosecutor to have advised us of that rule? This case is similar, Judge, because what you weren't advised of is Mass Rule 27B. See, everybody focused on Roth and Juvenile and Bluford, where all of them were single counts with lesser included. In the Roth case, the SJC decided that it prohibited judges like yourselves from inquiring into the vote. You couldn't ask the jury, well, if you haven't decided on manslaughter, what about involuntary manslaughter? What about OUI? But this is different because we have 3 counts, not 1. And Rule 27B that you were not advised of, and we contend, of course, the burden was on the table of the side that wants to re-prosecute her, says as follows. The judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. The advisory note is even more explicit. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree on.
Defense has cited some great case law here, arguing their support of their motion.
You provided a viable option to a declaration of a mistrial. It would have justified the courts, it would have required the court, as well as justified, to ask the jury whether or not it was an impasse on all counts, or rather than just one. So the Supreme Court not only puts the heavy burden on the prosecutor, it provides a set of guidelines which were established back by the Stewart case and repeated most recently by the Taylor case. And they even call them 2 principles guiding our review of manifest necessity. One is counsel must have been given, and the word must implies it as a mandatory, as an imperative. Quote, counsel must have been given full opportunity to be heard, and I'll address that second. And, quote, the trial judge must have given careful consideration to alternatives to a mistrial. These are legal imperatives, and we contend respectfully, for a variety of reasons, that neither of those 2 guiding principles were met by the evidence of what occurred on July 1, where we have the chronology of, Your Honor, taking argument from counsel regarding the morning note, and the prosecutor didn't want a TUI instruction, Defense counsel did, Your Honor, elected to give a Tui instruction. And 4 hours later, the jury sent a second note. And unfortunately, there was no convening of counsel and no request for counsel's position, no opportunity for Mr. Yannetti and Jackson to speak to Ms. Reed. After all, it's her rights, not just theirs. And there was this lack of consideration, careful consideration
He's blaming
of
her.
Rule 27B, which the prosecutor failed to bring to the court's attention. You know,
There's cheering outside.
again, usually this would be an issue where the defense counsel could be criticized when they don't object to instructions after trial instructions. The Court of Appeals makes it very hard for appellate lawyers to succeed in reversing a judge's not providing an instruction that later they win. But this is double jeopardy. This is different. This is why all of those cases, the U.S. Supreme Court in Arizona, the Supreme Judicial Court in Stewart, in Nicole, the Appeals Court in a case, Commonwealth versus Oregon, that we've cited. In light of the importance to the defendant the right to be free of exposure to second jeopardy, the burden of justifying a mistrial rests on the prosecutor. And so again, it's the default. If these procedural guidelines, these principles, where the court must consider any viable alternative, just the judge may not know every rule at every moment, just like the judge in Nicole did. It's on the Commonwealth to have advised your judge. So this was a case that really comes down to whether or not there could be deference to a judicial ruling when it was made without meeting the criteria of full opportunity for the defense to be heard before the court read the final note and issued its final order, and a full opportunity for the court to consider the alternatives to the declaration of mistrial. I would say to Your Honor that this is not easy. This was a long trial. Prosecutors had strong evidence that the jury was in fact deadlocked, at an impasse on count 2. The prosecutor has strong evidence that in fact the jury was not at an impasse on counts 1 and 3. They have to meet a burden of demonstrating to the court that they gave you all of the alternatives to the declaration of mistrial. And they should want, I submit, in a search for justice in this courthouse, where we don't want somebody who's found innocent once to face the second trial for the very same offense. That's the whole principle, the centrality of double jeopardy. Justice Douglas and Black's words in Green. They should join us in asking the court to establish a procedure in Your Honor's discretion that either allows the defense lawyers to supplement the declarations with juror affidavits, or cut right to it, that the attorney declarations satisfy our burden of production. And Ms. Reed was acquitted. Bring the jurors in, Judge, hear from them. Beg you, it's the right thing to do. Thank you very much.
All right, defense made great arguments. Most of it blaming the judge, but putting the burden on Lally.
Where were you?
Oh man, we could hear back. We could hear if you were right there. We can't hear here.
Your Honor, I'm also would ask, request that the defendant's motion to dismiss be denied, as it was not a verdict returned.
Counsel had more than adequate opportunity to be heard and object to the declaration of the mistrial in this case, and the mistrial was declared as a manifest necessity. To that last point, as it applies to what counsel was referencing in regard to Rule 27B, what I would submit there is there's a stark difference between what Rule 27B encompasses and what counsel is asking for the court to do. And what I would say is there's a difference between what Rule 27B talks about, which is taking, or the right of a court to take partial verdicts, which certainly the court is entitled to do, if that were at any point in time indicated in any of the communications from the jury, or if there had been any communication whatsoever from the jury that they had reached a partial verdict. So Rule 27B has to do with taking of those partial verdicts, not inquiring or trying to extract or coerce a partial verdict by polling the jury who has declared repeatedly to the court that they're in an impasse. So simply put, Rule 27B just does not apply. When it comes to each of those respective points, the jury in this case, when one, did not return a verdict, and two, counsel had adequate and ample opportunity to object to the declaration of mistrial, and three, that the mistrial was declared out of clear manifest necessity, which the court, the case law, has repeatedly stated is the prototypical sort of evidence or example of what manifest necessity is. But to those points, it is backed by decades, if not centuries.
We lost all our audio there.
Does quite a twisting of logic into sort of a pretzel in order to have the circumstances of this case fit into the precedent. And there's a reason for that, because there is clear and unequivocal precedent on each of those points that goes back decades, if not centuries. Commonwealth versus the juvenile is a case directly on point. And as the court is well aware, that's a case in which following jury deliberations and the defendant having been convicted after trial, one of the court officers found a verdict slip in the jury deliberation room in which the verdict slip was marked not guilty. That case stands for the proposition that where those slips were in contradiction of the jury's report to the judge in open court, that they were deadlocked, that does not, the not guilty finding on the verdict slip does not contravene or overrule the verdict as it is applied in open court. Quoting from that case, and I think it's directly applicable to what's been provided to the court so far, it states, it is not enough to show that the jury may have agreed on some issues at some time. If that limited showing were to control, uncertainties would be invited. And that's exactly what the defendant is asking the court to do in this case, is in contravention to that case law, in juvenile, in Bluefield, in Roth, in Gray, in all of the cases over the decades in the centuries dealing with this. Bluefield itself states very clearly, the very object of the jury system, after all, is to secure unanimity by comparison of views and by arguments among the jurors themselves. A single juror's change of mind is all it takes to require the jury to reconsider a greater offense. And that also comes in Commonwealth versus Carnes as well. But what it states, Your Honor, this jury was instructed, not only instructed orally for a lengthy time, but was provided with written copies of those instructions that the court gave. That stated on at least 9 or 10 different times exactly what the unanimous verdict was and how to come to that unanimous verdict and how to report that unanimous verdict. And there is no verdict that was returned stating anything in this case. And in particular, the two charges that the defendant now complains of dealt with simple choice. There was a box for guilty and a box for not guilty. Neither was charged, neither was checked, neither was returned to the court at any point in time. There is no verdict in this case. Now, as far as whatever those communications that the jurors are referencing, what the Commonwealth would say, Your Honor, is the jurors did nothing wrong in this case. The court did nothing wrong in this case. The court applied the law as it exists to this case. There's nothing special about this case. There's no special application or procedure that needs to be developed, created, or employed as it applies to this case or this defendant. This defendant, in this case, should be treated as any similarly situated defendant or any similarly situated case within the court system. These jurors, as the courts refer to them as an extraordinary jury, and I know the court had opportunity to observe the jury throughout the course of the lengthy trial and to review the many communications that the jury submitted to them, which the Commonwealth would submit were thoughtful, were deliberate, were intelligent, were insightful. This jury told the court on multiple times that they reached an impasse as far as their deliberations were concerned, as it pertained to the charges. In the final note that was submitted to the court, they referred to the charges in the plurality, twice within that note, as it pertains to exactly what they were stopped. When it comes to what they were communicating and reporting to be at an impasse in regards, they referred to it as charges multiple times. Whatever point jurors may have felt, the other thing I would say about the jury is, and this goes to the precise reason of why the procedures suggested by counsel are completely inappropriate in direct contradiction of what the case law says. I can't imagine whatever the jurors have undergone since July 1st, as far as extraneous influences, whether they're personal, professional, who they talked to, what they talked about, how those things have formulated in their minds. The intense pressure that they felt just looking at the affidavit from the one juror in regard to the comment that the court had allowed with reference to the jurors' information remaining anonymous, at least for the time being. With respect to that, that is exactly what the case law advises against and governs as far as taking this sort of post hoc, weeks or months after a verdict has been returned or not returned, and then asking people to put themselves back in a position and indicate to the court exactly what was going on in that deliberative process. Asking them how they voted or what their vote was is infringing into that deliberative process that is specifically excluded from any sort of point of contention or inquiry by counsel, by the court, at any point in time. When it comes to the adequate opportunity that counsel had to object or to suggest anything else, this is the very first time that the jury gave any sort of note or indication beyond the first note asking for a report. Mr. Yannetti was asking for Tui Rodriguez. And understanding that asking for Tui Rodriguez is not equivalent to requesting a mistrial. It's the first step in that process, and experienced counsel knows that. And even in that first note, the jury had not indicated that their deliberations were done, or that they had done thorough deliberations. They weren't asking anything. They were just reporting to the court simply where they were in their deliberative process at that point, reported to be at an impasse. Counsel, and these are Mr. Yannetti's own words, on both occasions indicated that from them, or argued for Tui Rodriguez on both of those first two notes that came from the jury, that this jury was emphatic and that they were, quote-unquote, hopelessly deadlocked. That is what counsel was asking for. What counsel is intimating there and making an argument about is for mistrial at those particular points, or at least leading down. Now, as far, and this is also, again, as I stated, backed by the case of Ray versus Commonwealth states, counsel's request for Tui Rodriguez instructions permits, quote, the inference that both parties were provided an opportunity to confer on possible alternatives to mistrial. Pereira versus Pereira is on point with that particular point as well. And I think it's also important to consider this in the context of this particular case and this particular trial. This is counsel who was not shy, did not have any misgivings about presenting any sort of argument or any sort of argument against the court's decisions when it came to anything that was even a perceived slight measure against the defendant's interest. And I would direct the court to the verdict slip argument that was made post-trial as well. Getting to the manifest necessity, Your Honor, As I stated, what the case law clearly states is that a prototypical example of a manifest necessity is a deadlock jury or a hung jury. And that is what we have in this case. It's clear, it's unambiguous from all the communications, even Mr. Unetti during his arguments for the Julie Rodriguez recognized the same. The dangers of coercion when it comes to a deadlock jury are amply stated throughout the case law, as far as Ray, as far as Cruz. The court was never required and has never been required, and that goes from the Blueford decision from the United States Supreme Court to the Supreme Judicial Court of this Commonwealth, that there is no requirement that the court makes any sort of polling or has any sort of asking when it comes to those how the jury stands or whether or not they have a vote or whether or not they have a partial vote. I would also submit, Your Honor, that counsel's argument is a little disingenuous when it comes to indicating that those cases only apply when you're talking about charges with lesser included or charges that have a multiplicity of different findings that the jury can make. Because it ignores the fact that there are those two, and the two very charges or indictments that the defendant is seeking to dismiss here were very simple. Not guilty or guilty. Those are the two boxes to be checked. So in those instances, it may be permissible for the court to require a poll. But the coercion and the fear of that that's developed through the case law is inherent within the second count, which had all of those lesser included charges, which is exactly what the case law and the rules prescribe as far as not allowing for the court to inquire into those types of scenarios. So, yes, the defendant's position is the court should have polled or inquired only as to indictments 1 and 3 and not to as indictment number 2. But again, I don't know that there's any requirement for the court to do that. I don't know exactly how the court is to do that when it comes to those types of coercive pollings of the jury while they're still deliberating. The notes and the communications from the jury, again, on 3 separate occasions, and very deliberately, as far as the language that was used, declared themselves to be at an impasse on 3 separate occasions, the last of which included language to the effect that any further deliberations would be futile. That is the very definition of manifest necessity, and left this court with absolutely no alternative other than to declare mistrial. And it is clear from the language of the jury's communications to the court, and it's clear from the case law and the rules and the law itself as far as what the court can do. The two areas that counsel is talking about and sort of asking for an extension or creation of a new law, again, sort of special or deferential treatment to this case or this defendant. The two areas in which the court can make post-trial inquiry have to do with some sort of bias, if there's an issue raised in regard to whether it's due to racial discrimination, gender discrimination, or some other protected class. So that sort of bias implicit in the jury's deliberative processes, or in an instance
Maybe he lost a page of his notes. Mr. Lally suggested that
some sort of allegation to the jurors of extraneous influence. The defendant's not raising either of those issues. Specifically within those cases, what the court states, which is obviously binding on your own, is that those carve-outs for extraneous influences or bias on the parts of the deliberating jurors are permissible areas for post-trial inquiry. What all those cases also say is any inquiry into the deliberative process or exactly what counsel is proposing here is specifically prohibited by those cases that have developed over the decades. Commonwealth versus Moore states specifically that Massachusetts continues to adhere to common law principles barring inquiry into the contents of jury deliberations and any impeachment of jury verdicts based on information gained from such inappropriate inquiry. Now, the reason that the Commonwealth did not respond directly to the jurors when it came to them expressing or wishing to have discussions about their deliberative process or their votes is specifically for the Rule of Professional Conduct 3.5c states specifically that inquiries into those topics are not allowed. The case law that is derived around that and since that corroborates. Simply because someone called you first does not then allow for that inquiry to occur. So whether or not you initiate the call to the juror or the juror calls you, it still does not allow for counsel or the court to then have these conversations with these jurors that delves into their deliberative processes or
do we get a heartbeat
their
monitor?
deliberations. The specific type of coercion that is feared by the courts when it comes into this, and I'll sort of condense quote from Commonwealth versus Law. And it states simply, one cannot assume from the mere report of deadlock that there is any final verdict lurking within that deadlock that may be extracted. Such inquiries of the jury may succeed in extracting a partial verdict, but we could not have confidence that that partial verdict was the product of a thoughtful and thorough deliberation process. The risks of jurors' coercion are too high, and the reliability of any such partial verdict returned is too low to warrant such an approach to salvaging some partial result from a deadlocked jury. Simply put, Your Honor, what counsel is proposing as far as what the court should do is prohibited by the rules, it's prohibited by the law, it's prohibited by the development of case law over decades and centuries as to what is permitted. Certainly, the Commonwealth nor anyone wants to try someone who has been acquitted by a jury of their peers or retry them in the same case. That's not what's happening. There was no verdict returned by this jury. Counsel had more than an adequate opportunity to address the court in relation to the declaration of this trial, and the court did absolutely nothing wrong in finding a manifest necessity as the only alternative that could have been employed in that particular instance. Polling the jury then, polling the jury now. It's simply not permitted by the rules, it's not appropriate, and therefore the defendant's motion should be denied. Thank you.
May I reply, please? Thank you. Two cases that Mr. Lally relied on, and they both stand for very different propositions of law. Commonwealth versus juvenile, it's actually Juvenile versus Commonwealth at 392 Mass 52, 1984. It says the judge was under no duty to inquire as to the status of the jury's deliberations on each of the lesser included charges within the murder complaint. Footnote 1 of that opinion says, quote, we deal here with a complaint charging a single murder, where a complaint or indictment in multiple counts charges multiple crimes, e.g. 2 separate murders. A general verdict could be returned as to one of the counts, despite deadlock on other counts. Commonwealth versus juvenile was as if count 2 in this case was the only count, and they discouraged any kind of court questions as to where the jury stood on lesser includeds. And that's the principle of Commonwealth v. Roth, the other case that Mr. Lally figured. That case created a dichotomy where the court was asked whether or not a judge was permitted to ask the jury about lesser includeds. And because of the fear that a court's mere question could have a kind of domino effect in coercing jurors to reach compromises as to lesser includeds, the court prohibited such questioning as to lesser includeds. But the court distinguished throughout this lengthy SJC opinion our case, where we're not dealing with one count vertically with multiple charges, we're dealing horizontally with 3 separate charges. Both Buford and the juvenile had evidence that the unanimous verdict that the defense was claiming occurred before the end of deliberations. In the juvenile, I think weeks or days later, a court officer found some verdict slips. Nobody knew when they were written. In Bluford, the Supreme Court case, where there was a statement to the court that we've reached a decision on one count, the court sent them out under Arkansas law because they hadn't decided, just what they would. They needed to decide all the different allegations within a single charge, and they came back and said we're deadlocked on everything. But there's no risk of jury coercion when a court is asking the jury whether they reached a verdict on other charges other than the one they were deadlocked on. There's no risk of jury coercion saying, does your note reflect all charges rather than one? Your Honor instructed the jury, page 46 of the instructions, you should continue deliberating until you have reached a final verdict on each charge. We don't know whether the jury understood that instruction to mean that we can't come back and tell the court affirmatively that we've reached two decisions, two general verdicts, but we're in an impasse on a third one. The Commonwealth talked about the risks that some of the jurors might be exposed to media, and that's certainly more than true in the Sanaev case, where they've had just an overwhelming amount of media regarding the catastrophe at the Boston Marathon in 2013, and the government's investigation, the trials. Jurors knew what one jury decided, and yet the First Circuit said that's not a prohibition about a court exercising authority to ask the right questions. Judge, you're an experienced jurist. I trust you to be able to determine whether or not a juror telling you they reached a verdict, to determine whether it was final or whether it was somehow influenced by the media. Your Honor does that every day when you pick jurors on the front end to determine whether they're biased or unbiased. It's certainly not a prohibition that should insulate an acquittal and allow a re-prosecution. The question at the end for the jurors would not be about the deliberative process. I understand Mr. Lally's citation to Moore and the discomfort and the rules that say jurors should not be asked questions by anyone regarding, why did the Commonwealth not persuade you that Ms. Reed was guilty? Or what did you think of this witness's credibility? Or why did you vote a certain way? Or what did the other 11 jurors say? A deliberating jury is not a focus group. It's not a place, for lawyers to ask about the views of 12 jurors, through the interview with one juror. But Your Honor is being asked to do no more than ask them what you would ask if they came out and said we had a verdict, which is, did you unanimously determine as a final determination that Ms. Reed is innocent of counts 1 and 3? Was your decision unanimous? Did any juror dispute it? That's very different than probing the subjective state of mind or probing for what other jurors said that caused somebody to reach that unanimous verdict. If Mr. Lally's concerned it wasn't a final verdict, Your Honor can ask the question, was it a final verdict? Was there ever a deliberation again after you reached that unanimous decision? In terms of the argument about Tui and Mr. Yannetti saying, well, they're deadlocked, if he wanted a mistrial, he could have asked for a mistrial. That Your Honor would have, of course, had the discretion to deny it after 4 or 5 days of deliberation. He asked for a Tui instruction. And it's inferred by a Tui or a Rodriguez instruction in the state court. Tui, I think it's a 19th century federal case, is that you have hope When you're asking for the Toohey instruction, my experience, usually the prosecutor who's confident in the jury that wants the Toohey instruction to try to get the majority to overcome the minority and get to a guilty verdict. Here you have the defense lawyer asking for a Toohey instruction, reflecting that he wanted further deliberations. And so it's no answer, and the Ray case does not say that when you ask for a Toohey instruction, you are really asking for something more than a Toohey instruction. Toohey means, I want this jury to reach a decision. And that's what Mr. Yannetti was saying during those two colloquies on the Friday before and then on July 1. We're not asking the jury to impeach a verdict. We're not asking for an inquiry that would be prohibited. I know the federal rule is 606B. I think the state number might be about the same way in terms of asking the jury for their state of mind. We're asking the court to conduct a voir dire that Mr. Lally agreed would be done if our argument is one of the 12 jurors was biased. If our argument was, well, we now have new evidence one of the jurors read on internet. We have evidence here that the jury acquitted Ms. Reed. What can be more central to the core values of our criminal justice system than to make a judicial determination with a respected and experienced Superior Court judge, whether that's so or not, and if it's so, stop her re-prosecution, because that would be a horror to make her convince 24 jurors of her innocence, a second 12 when she's already convinced the first 12. Thank you, Judge.
Thank you. Any response, Mr. Lally, or are you all set? All right, thank you very much. I'll take this under advisement.
Thanks, Judge.
Boom. She's gone.
Judge, when I hand the Nicole case to you.
Sure, thank you.
This is going under advisement, which means I'm going to put a pin in it.
Football rise.
I don't want to go before we see our only fan. Celine Dion.
Goodbye.
Goodbye. Apparently one of the lawyers is packing up the courtroom microphone in his suitcase, taking it with him. I think it's Lally. I think if we paid attention during the last hearing, the judge said she would not be making a decision this time, so it's expected. A lot of you got that answer right in our poll. No decision today, will be under advisement. I saw one green pen there. Green pen. The bailiff's like, hey, wrap it up here. Wrap it up. Let's see if we get a little fan. The two sides are let out of court separately just for security reasons, because there's quite a crowd outside. Looks like we're not getting our only fan apparently. So, I would say that was actually some fairly decent arguments. I have to say that defense resonated with me a little bit more. They had a lot of case law. They had a lot of history that seemed to be very similar to it, even though it was a little bit different, very similar to their situation and proposed solution for how to handle that. The short of the matter is they had to say it, and they did. They said, Judge, it was a mistake. The jury should have been asked. And they said that in such a way, they're saying it's the prosecutor's responsibility to make sure that happens. So they blame the prosecutor for the judge not doing it, which is a nice way of giving the judge a backdoor without admitting fault. But yeah, I'm sure absolute circus outside, just absolutely crazy. All right. Let's see. Lally was a dry presentation, but also very, very solid. He always has been. Lally is a good lawyer. He's not the sort of lawyer that's going to like draw by, passerbyers and like, wow, listen to this guy speak. That's not Lally, and that will never be him. As a matter of fact, I think I might have fallen asleep during his presentation, but he is a good lawyer, and he had a prepared argument that he gave effectively. Just not very. What is it? It wasn't very gripping. Let's see. Is a circus outside? We're still watching to see if they show us the only fan. I'm not seeing it. We've got court. It looks like the people in support of Karen Reed have still not been let out. They're still standing, waiting to be released, which is just an indication of how crazy it is on the outside. And we heard throughout this hearing, there were moments where you could hear cheering, and we couldn't tell which side was cheering. I would guess that it's probably Karen Reed's side, if I were to put a guess on that. But loud cheering, audible over the mics in the courtroom, which was just wild, absolutely crazy. All right, we have a little bit more to do today. First of all, Judge Boyd, looks like we just had a jury question. Let's see. Oops, let me go back there. I think we had a jury question, Judge Boyd. Did one of the mods catch the question? I don't want to go back and watch the whole thing about that, but Judge Boyd's jury has already determined guilt. This is in the 90-mile-per-hour crash situation where the guy that drove up on stalled traffic and hit the back car at 90 miles an hour, killing the lady who was in that car. They already came up and said, yes, he's guilty. But now the jury in this state, in Texas, wants to not just one question, multiple questions. Okay, I'm gonna go back here. Just 1 second. Let's see. Let's jump back to Boyd. Let's see when she pops up here. Judge Boyd. Why is it just spinning? Give me a second here. Let's find the latest. I want these juror questions. This will just take a couple minutes. Let's see. Samantha has an update here. A juror had a medical emergency and documentation was requested. Judge supplied documents and told them to continue deliberations. Is that bedroom door catty cornered? Yes, it's a double wide. It's like two doors that swing open, and the hallway is right down here. So I keep that closed so the kids can run in and about. It will see all the way down to the kitchen down this hallway. But if I were to turn the other way, you would see I've got a walk-in closet just to the right of this, like right there, and then we've got another like a hallway that's got a makeup room. I don't know, green room. It's a sink and a mirror and cabinets and stuff, and then a door beyond that is the bathroom and shower. So it's a nice Airbnb. We really like it. When I leave, I'll give you the name of it and give it recommendations. Okay. It is not playing for me. I'm not getting Judge Boyd. Oh, there she is. Okay, hang on. Here we go. Let's go to on camera 8, right?
Yeah. All right, everyone. The court is calling 2022 CR 11862, State of Texas versus Alexander Castro. Could I have parties announced for the record for the state?
Daniel Bar, case of your state.
Look at the
Defense?
attorney who's asleep in the
John
chair.
Holbein and Jason Goss with Mr. Castro.
And Mr. Castro is present?
Yes, Judge.
He's back there in the
All right. The court has received several questions from the jury. The first question was, we have a juror with an urgent medical situation. Please come see us. So both parties were aware of that. Is that correct, State?
Yes, Your Honor. Yes.
Defense?
Yes, Judge.
And what ended up happening is EMS was called. The juror wants to continue to deliberate. Any
Whoa.
objections from the state or the defense?
No, Your Honor.
None from defense.
Any objections to the jurors continuing to deliberate with this juror? State?
No.
Defense?
No.
Called
The
an
next
ambulance. He's
question.
like, no, I want to do my civic
States.
duty.
If the county clerk document was entered into evidence, can we be provided that document? The court proposes the following supplemental charge. With reference to your inquiry, you now have before you all the testimony, exhibits, and evidence that was admitted, and you are instructed to continue your deliberations. Did both parties have a chance to review the juror question?
Yes, Your Honor.
Yes.
Any objection to the court's supplemental charge?
No, Your Honor.
No.
Next question. We have a disagreement that the defense had a sworn document from the county clerk that the defendant had not been convicted of a felony in this or any other state. Can we have court reporter document about this topic? Have both parties had a chance to review the question? State? Defense?
Yes.
Any objection to the following supplemental charge? With reference to your inquiry, review the charge of court on punishment, page 2, paragraph 3. Any objection? State? Defense? Any objection?
No objection.
The next question the jurors have. The jurors are in disagreement about the defendant's mother's testimony regarding knowledge of versus certainty that her son did not have prior convictions of felonies. Can you please provide court reporter's transcript, including the question asked from the attorney, to prompt her? Have both parties had a chance to review the question? State?
Yes, Your Honor.
Defense?
Yes, Judge.
Have both parties had a chance to review the certified transcript prepared by the court reporter as the answer? State?
Yes, Your Honor.
Defense? Any objection to that being the answer? State?
No, Your Honor.
Defense?
No objection.
Next question. The jury is in disagreement about the charge of the court on punishment, specifically page 2, last sentence. It will be granted by the court. We don't know who the court is. Can you clarify? Have both parties had a chance to review the juror's question? State?
Jury says, who is
Defense.
the court?
Yes, Judge.
Any objection to the supplemental charge? The court is the presiding judge, Judge Stephanie Boyd. Any objections? State? Defense?
No, Judge.
Next question. The jury is in disagreement about probation, specifically if we have any say in the term or conditions, or if the court decides. Can you please clarify? Have both parties had a chance to review the question? State?
Yes.
Defense?
Yes, Judge.
Any objection to the following supplemental charge? With reference to your inquiry, you have all the law before you. Please continue your deliberations. State? Any objections?
No, Your Honor.
Defense? Any objections?
No objection.
Any objection to the court sending those questions with the answers attached to the jurors? State? Defense?
No, Judge.
And with regards to the first question about the juror needing medical, that's not going to go back because that wasn't a legal question for us to decide. All right. Thank you, Deputy Laura. If you'll take that back to them. And
Man.
Maria, if you will keep this as a part of your record, please.
Yes, Judge.
This jury is struggling to reach a decision on the
All
sentencing.
right. So everyone, we will recess and see where we are.
Thank you, Judge.
You're welcome. And if y'all want to go to lunch, y'all are free to go to lunch. As I said, for both family, nothing will happen unless.
Yeah, nothing will happen unless you're here. Wow. This jury's been deliberating forever. This is crazy. Let's see. Abby J says, what do we have on schedule for next week? Tell us. The Arizona trial of the murder of a journalist. The jury selection starts on Monday, so that's going to be kicking off. We're going to be there with that one. Let's see. So that's a new trial kicking off early in the week. I don't know how long jury selection is going to go. The jury doesn't even sound close to making a decision. Yeah, this is wild. And they're just deciding they're just deciding the sentence. The verdict is done. They all are unanimous on guilty. And now they're just deciding on their recommended punishment, and it's taken days. Let's see. Let's see what else. That's at least an hour. It's at least an hour before she goes live, assuming the jury reaches an agreement. I agree. So that gives us time to dig into some Young Thug documents, if that works for y'all. Give me a second here. Let me pull these up. Commonwealth, okay, got all those. We want... Here we go. This is going to be the order on defendant Stillwell renewed motion for fair and constitutional trial. So let's get this over here where we can read that. Let's send it to... let's see. Where's this one? Send it to the MacBook Pro. Okay, sorry, I like this setup a little bit, but some parts of it are really frustrating. And we'll bring that down here to camera 6 so I can see it. Continuous scroll and take 6. Okay, so now we're jumping. We've covered several courts today. So we've covered Karen Reed. We covered an update on Judge Stephanie Boyd's trial, her jury trial that we've watched most of that court together on. And now we're jumping to Young Thug. Not that we're going to watch Young Thug, because Young Thug is scheduled to go on for like another year. It's nuts. It's crazy. But there's been some very spicy exchanges in Young Thug recently, and we're interested in that. So we're gonna bring that up here. Let's see. Do we have that? Where's program out? Okay. So let's get rid of. There's a comment. Nope. Wrong computer. There we go. Abby J says, we love the spice. Josh says, Recovery Addict, Weather Watch, and myself missed Lally's argument. We want to hear that first. We weren't here when you shared that. I missed it as well. I was sleeping. It was his argument was no. Basically, he says, no, the jury didn't reach a verdict, so we want to retry this. But he didn't have a lot of case law supporting that. It was interesting. It was mostly just his own reasoning. A lot of case law on the side of defense. All right, so now, what do you guys see? Let me see what you guys see. Sorry, I've mixed up my monitors. Let's go live. Do you see chat or me? Oh yeah, you see the. That works. Okay, here we go. So back to Young Thug. A little bit of reading, light reading. Defendant Stillwell raises numerous assertions of error, impropriety, prosecutorial misconduct, and judicial partiality, which he asserts have resulted in a denial of his constitutional rights to due process and a fair trial. The pertinent determination is whether such events, if they occurred as alleged, warrant a mistrial with prejudice, dismissal of the indictment with prejudice, which would have the same effect, or disqualification of the prosecutors. So this is the second disqualification of prosecutors we've watched this week. Claim 1, a plague of jury discovery violations, missing police reports, and Brady violations. Discovery, they say a plague of discovery violations. Discovery is being addressed. This court has ordered the state to timely produce all discovery and undertake a concerted effort to secure and provide all police reports, including asking current APD personnel with specificity to search for and produce reports on the case. Hang on. I think I'm allergic to something here. This that we're getting at, the judge, this is the new judge in the Young Thug trial, And this is the first time she's handled a discovery complaint from the defense saying the state isn't giving us stuff. And she's like, oh, look, oh, it was oversight? Oh, okay. Well, I'm just going to tell you, you have to give everything now, so we won't have any more. The defense is livid. They're like, oh, it's the first time for you, Judge. But with Judge Glanville, who we got kicked off the case, there was like 6 or 7 of these times. We had these same arguments, and every time they're like, oops, it was an oversight, sorry. And they're like, this is not new to us. We've heard the same argument over and over. But the judge says it's being addressed, and everyone's going to turn over all the reports. As recently as the court proceedings on Friday, August 1st, the court confirmed the state's understanding that Brady obligations include the disclosure of material impeachment items and reminded the state of its continuing obligations under Brady. The state represented to the court that it has fulfilled all its Brady obligations. The court will address remedial Brady action later in this order. Claim 2. Prosecutorial failure to follow court orders, making of specious. Please tell me that's a typo. Did I learn a new word today? Red pen? Hey Siri, define specious.
Specious means superficially plausible, but actually wrong.
Ha, I like it. Specious. The making of specious allegations against defense counsel and counsel for a witness, and lack of candor to the court. Lack of candor to the court. Basically, that's not being 100% truthful. Any past failure of the prosecutors to follow orders of the court is a matter of record. Aside from the broad assertion of a denial of a defendant's rights to due process in a fair trial, no specifics establishing this assertion and no claim of resulting legal error is alleged. Any potential error stemming from prosecutorial failure to follow court orders may be addressed on motion for new trial or direct appeal, assuming any conviction. She's basically, oh, you can take it up on appeal. That's what she's saying. Any specious allegations, these wrong allegations against the defense counsel, counsel for a witness, or lack of candor with the court is, at minimum, extremely unfortunate. These items do not, however, establish a denial of defendant's rights to due process or a fair trial, and the court at present declines to impose the extreme sanction of removal of any offending prosecutors. Claim 3. Improper evidentiary rulings by the predecessor judge. That's Glanville. A defendant is entitled to a fair trial, but not a perfect one. For there are no perfect trials. That's Pickles versus State. That's case law. Evidentiary error, which involves mistakes under Georgia's procedural rules and evidence law, rather than any constitutional violation. Judge Boyd is live again. Oh my goodness. Let's see. Judge Boyd. Hold tight. Her camera is live. We're gonna bring audio in from Judge Boyd. As soon as she goes live, we'll take camera 2 and bring that to you. But until then, we're gonna stick with Young Thug because it might be 15 minutes before. I thought she told everyone to go to lunch, didn't she? She told them all to go to lunch. So a big, huge, fat footnote here at the bottom of page 2. It's almost half a page. The court reminds all counsel that every Georgia attorney is bound by our rules of professional conduct and owes a duty of candor to the court.
All right, we're back on the record in 2022 CR 11862, State versus Alexander Castro. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas. Daniel Escobar and J.C. Garahan for the state of Texas.
For the defense?
Jasmine Lee for Mr. Castro.
And Mr. Castro is present?
Yes, he is, Judge.
The court has received the following questions from the jury. First question, is there the option to continue deliberations during the weekend hours? Have both parties had a chance to review the question? State?
Yes, Judge.
Defense?
Yes, Judge.
Any objection to the following supplemental with reference to your inquiry? No. Please continue your deliberations. Any objection? State?
No, Your Honor.
Defense?
None for defense.
The next question the court has received. The jury is in disagreement regarding the amount of probation time given. Some jurors believe that the initial term of confinement stated on page 8, number 1. Other jurors believe that the term of probation is not the same as page 8, number 1, but instead awarded by the court. Have both parties had a chance to review the jurors' question? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objection to the following supplemental charge? With reference to your inquiry, you have all the law before you. Please continue your deliberations. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No objection.
Any objection to the question and supplemental charge being sent back to the jurors? State?
No, Judge.
Defense?
No, Judge.
All right, thank you.
Thank you.
And you may take it back, Deputy Laura.
Now we're on break, and now we're going to go back. Man, the jury there, they are serious. The judge is going to have some great words for that jury. I cannot wait to hear the post sentence little colloquy that the judge has with the jury and thanking them for their service, because this is an extraordinary jury. It really is. All right, back to Young Thug. Little whiplash here. We're going back. Let's see. These ethical and professional obligations should be scrumptious. Look at this word. This word right here. I can't highlight it. Scrumptiously. Is that right? Scrumptiously? Hey, Siri, define scrumptiously.
Okay, I found this on the web for define scrumptiously. Check it out.
Not scrumptiously. I didn't have an M in there. Hey, Siri, define scrupulously.
Scrupulously means?
Scrupulously.
In a very careful and thorough way.
These obligations should be done in a very careful and thorough way. Why couldn't you just say that? Why do you have to say scrupulous? Why do you have to use a hard word? Scrupulously honored, and prosecutors, above all, should endeavor to comport themselves so as to be above reproach on such matters. That's in bold. The judge means that. The court understands that it has the authority to sanction counsel for violations of the rules of professional conduct that occur during and impact on a case before this court. The court declines that invitation at present. However, any future persistent failure to abide by the rules of professional conduct or lack of candor with the court may trigger the extreme sanction of removal from this case. Okay, so she's not kidding. She's like, I'm not going to do it now, but if this happens again, so help me, I will stop this bus right here. States June 7, 2024 motion for immunity and compelled testimony of Copeland states, on Thursday, June 6, 2024, after an encounter with defense team members and members of the Fulton County District Attorney's Office, Copeland stated to an investigator and to an attorney with the Office of Fulton County District Attorney that Copeland might attempt to plead the Fifth in order to avoid testifying against members of YSL. That's motion 11. Even assuming this is a willful misrepresentation as opposed to inartful drafting or misunderstanding, the gravamen, is that, hey Siri, define gravamen.
Gravamen means the essence or most serious part of a complaint or accusation.
I'm learning so much today. The gravamen of the representation is that the Copeland had indicated that he might plead the Fifth to avoid testifying in this trial. The sequence of alleged events is not the material aspect of the motion. Claim number 4, mistreatment of defendants and their counsel by the predecessor judge. Aside from a blanket assertion, the motion does not detail any alleged mistreatment of the defendants. The alleged mistreatment of defense counsel, detailed in paragraph 9A, E, and H, is not alleged to have occurred in front of the jury, and, even accepted at face value, would not rise to the level of a violation of the defendant's due process or fair trial rights. As to remedies, the predecessor judge has been recused, and the contempt issue outlined is moot. That means it doesn't matter anymore. We got rid of the judge. It's going to be fair now. Turning to the alleged mistreatment in front of the jury, this is bigger. In front of the jury, that's a problem. A judge has broad latitude in determining how to control the courtroom, and directing attorneys to sit down when overruling objections falls within that latitude. This court will give remedial instruction directing the jury to disregard any disparaging remarks about counsel. So the jury will hear, if I yell at an attorney, don't take that personally. That's just us. Don't read anything into that. Claim 5. Improprieties in and illegality of the June 7, 2024 ex parte conference. In open court on June 7, 2024, the prosecution requested an ex parte conference with the court. June 7, 2024 transcript, page 94. The defense was therefore on notice of this request. The defense also knew that the request was not to secure immunity for Copeland, as the immunity order had been signed in open court earlier in the same day's proceedings. Even assuming a right to be present for this June 7th conference, no one on the defense team objected to the request or sought more information about it. thereby waiving any right to be present for that conference. Okay, so they said the court asked for an ex parte, or prosecutors asked for an ex parte meeting. Defense heard them ask, and they didn't complain. So, sorry, your motion to object to this, even if it was illegal, it was not timely. Let's see. The proposition that the defendant waived your right to be present by failing to object after being informed of the trial judge meeting with the jury outside presence and defendant counsel. So they do have case law supporting that as well. As for the topic of this ex parte conference, defendant assigns nefarious intent to prosecutor Love's and Hilton's representations about their interactions with Copeland's main counsel, Jonathan Melnick, who went on vacation and assigned somebody else in his place and then said, "I quit." The court at this point declines the invitation to so view their representations, but refers the prosecutors to its footnote 1 herein. We'll look at the footnote in just a minute. Defendant complains that comments by the predecessor judge during this conference reveal his partiality to the state. Permitting the questionable accurateness of such characterizations, this issue has been mooted by the recusal of that judge from the case. The fix was to replace the judge. The judge has been replaced. Now the problem's gone. Quit complaining. That's what the new judge is saying. Claim number 6, illegality of the June 10th ex parte meeting. On June 10th, at the behest of Prosecutor Love, the predecessor judge held an on-the-record, in-chambers meeting with Love and standing counsel for Copeland, Kayla Bumpus, poor girl. June 7th, 2024, transcript of ex parte is pages 3 through 22. Following a recess at which time Love departed the meeting, Copeland and Prosecutor Hilton joined the meeting. Defendant's motion raises several challenges to this ex parte meeting. Did the defendant have a right to be present? Did the ex parte meeting amount to coercion of Copeland's testimony? And did any Brady violations occur? On the footnotes, we've got that Melnick supplemented the record with a statement in his place as to the representation of Copeland and addressed the asserted conflict of interest. Also, another footnote, the predecessor judge, I'm going to read this correctly. The predecessor judge's remarks regarding outside agitators are virtually identical to the remarks he had just made on the same topic in open court, remarks which he addressed to all counsel and which would not therefore logically include the defense counsel. The defense also raises the specter of another ex parte conversation between the prosecution and the predecessor judge, or that a portion of the June 10th ex parte meeting was not transcribed, because the predecessor judge seemed to know that the prosecution had a list of questions for Copeland despite there being no prior mention of such list during the ex parte meeting. This knowledge is easily accounted for. The prosecutors had specifically referenced such a list of questions reviewed by Ms. Hilton with Copeland on the record prior to the Friday proceedings, thus the innocuous source of the predecessor judge's knowledge. So he had a proper venue to get that information. Did the defendant have a right to be present? Defendant is correct that this meeting was about more than just the parameters of Copeland's immunity and whether he understood its potential ramifications. The initial stage of the meeting, before the first break, centered on the prosecution's concern with whether Copeland's main counsel was laboring under a conflict of interest and with the logistics of handling Copeland's testimony with standing counsel. But because these topics were all ancillary to Copeland's immunity grant, the topic of the meeting remained at its core, and as asserted by the prosecution, Copeland's immunity grant. Because the meeting dealt with Copeland's immunity grant and its ancillary issues, it was not a critical state of the trial at which the defendant has a right to be present. Here's the case law. When it says the defendant has a right to be present when his presence has a relation reasonably substantial to the fullness of his opportunity to defend himself against the charge, but not when his presence would be useless or its benefit but a shadow. Additional case law. The hearing. The presence of a defendant is a condition of due process to the extent that a fair and just hearing would be thwarted by his absence, and to that extent only. So defendant is correct. There are differences between the meeting in this case and the meeting in King versus State. For instance, the meeting in King was to secure immunity for a key prosecution witness, and the defense was aware of the immunity hearing was occurring. Back up to the footnotes. The court sympathizes with Mr. Melnick's understandable indignation at having his professionalism and his loyalties to his client questioned. The court likewise appreciates defense counsel's umbrage. The issue of Brady material is being generated during this ex parte meeting but not produced will be addressed below. As to the allegation made orally on Friday, August 2nd, that Brady material was revealed to the prosecution in an off-the-record conference between Hilton, Bumpus, and Copeland during a break in the ex parte meeting, see the court's separate order thereon. So here, the defense was not given notice of the meeting. The immunity had already been granted to a key prosecution witness, so the topic was not whether immunity was in the public interest. Instead, its topics were the adequacy of witnesses' legal representation and logistics of outstanding representation, as well as ensuring the witness correctly comprehended the meaning and impact of the immunity grant, what would and would not amount to contempt of the order granting immunity and compelling his testimony, and the potential consequences of failure to comply with the order. That puts a shiny sheen on it. But the state's reliance on King does not demand that all its facts be on all fours. The legal import of King for this claim is that because a defendant's rights are not the subject matter under consideration in proceedings surrounding a witness immunity grant, a defendant has no right to be present for discussions with the tribunal surrounding witness immunity. The fact here discussions included what testimony would subject the witness to a charge of perjury, what would subject him to punishment for contempt of the order compelling his testimony, and what that sanction might even entail, even if incorrect, does not change the analysis. Defendant's rights were still not the subject matter under consideration. So she's saying it doesn't matter. There is no right to be present, and quit complaining. Lowry found that because the hearing there also included discussion and ruling on the defendant's motion, mid-trial motion in limine regarding the witness using street names during testimony, absence of the defense violated defendant's statutory right to be present, though any constitutional error was waived. Here, there was no ex parte hearing nor discussion of any defense motions. The analysis confirms that the key, whether the defendant has a right to be present for witness immunity proceedings, is whether, for some reason, the defendant's rights are also a subject matter under consideration. Did she already comment about the meeting raising Brady issues? No, that's coming up, Mathis. So let's see. This is additional case law. Let's jump to was the witness testimony coerced? Separate from any defense right to be present for ancillary proceedings concerning witness immunity, the defendant has a right to a trial free of coerced testimony. That's when you're forcing somebody to testify a certain way. Defendant asserts that certain arguably inaccurate representations made by the prosecutors and the predecessor judge to Copeland about the law and derivative use of immunity, the applicable statute of limitations relating to what crime or crimes the defense does not specify, and the length of his possible incarceration for contempt coerced Copeland into testifying. Case law. Webb v. Texas is the touchstone for evaluating claims of coercion by the trial court of a witness's testimony. Archer v. State provides another example of a trial court overstepping its proper role of neutral arbiter and rendering involuntary a witness's determination whether to testify. Here, Copeland had the benefit of counsel. The predecessor judge did not, on the whole, use intimidating rhetoric. Seriously? But rather sought to ensure that Copeland understood the nuances of the decision he had to make, and he explained that many of the decisions about what could happen to Copeland were not his to make, but were up to the prosecutors. Still, some of the information provided to Copeland may have been inaccurate. While it is likely that Copeland was not induced by any intervertent or other inaccuracy to testify, the cleaner approach is simply to preterm it. Hey Siri, what does pretermit mean?
Predeterminate means to determine or decide something in advance.
Hey Siri, what does pretermit mean?
Predeterminate means to decide something in advance.
It's not predeterminate. It's pretermit. I need a red pen. English teacher, pretermit. The cleaner approach is to do something with this issue, acknowledging past inaccuracies and advise Copeland anew. This is the course the court has proposed, and the parties have affirmed its efficacy. There it is. Was there a Brady violation? Mathis, here we're at this part. So omit. So we're going to strike that part and inform him anew. Didn't the jury hear his testimony already, though? Are you just going to tell the jury, forget everything that happened during that fireworks portion of the trial? Was there a Brady violation? There has been a long-running and multifaceted proceeding. This has been. Challenges have been myriad and formidable. Frustrations may have been mounting while fortitude was waning. And a needle in a haystack is not always sometimes difficult to find, but also easily overlooked. The court does not attribute bad faith to anyone on this issue. That means that this is bad for the defense. Bad faith means that they intended to do this, that this was for possibly a strategic advantage by springing this evidence on the defense at a late point in the trial, right as it's about to be presented. But they're saying we didn't find that. There was no sign of bad faith. And yet, as soon as Copeland joins on June 10th, in Chambers' ex parte meeting proceedings, he states, "I have never been truthful a day in my life until I just made this statement right now." Copeland may have little credibility. He may speak in hyperbole. But the fact remains that for a defense attorney, this nugget by a key state's witness is gold. So when the prosecution not only did not reduce this statement to writing and produce it, but also asserted in court filings that defense had no entitlement to know the contents of the ex parte proceedings, this amounted to suppression, whether willful or otherwise, of what was objectively Brady impeachment material. The defense now knows of this statement, and indeed of all of what occurred during the June 10th ex parte meeting. The contents of the meeting were ultimately revealed during the course of trial and in time for the defense to utilize it. So the failure to produce and suppression of this information does not technically amount to a Brady violation. But the fact that a violation of a defendant's constitutional rights has been averted does not, under these circumstances, provide cause for celebration. Copeland has since been recalled into open court on August 6th, and in the presence of his counsel, Melnick, who also privately consulted with and advised Copeland, was provided clarifying and correct information on matters potentially impacting his choice whether or not to testify. All parties were present and consulted with the court prior to Copeland being re-advised. So, what this does provide is cause for sober reflection and an examination of the processes, procedures, and approaches that permitted this likely inadvertent but nonetheless serious Brady lapse to occur. She's not saying violation, Brady lapse. Defendant seeks as a sanction the disqualification of the state's two lead prosecutors. Because this does not appear to the court to have been a purposeful violation, but rather a negligent overlooking of the impeachment value of Copeland's in-chambers statement, the court does not order their disqualification. At the same time, the court is cognizant that defendant's liberty, as well as the liberty of his co-defendants at this trial, is at stake, that the prosecutors involved are knowledgeable and experienced, and this is not the first allegation of prosecutorial misconduct in this case. The court therefore orders, as a remedial measure, that the entire prosecution team working this trial submit to training on Brady and other professional obligations of a prosecutor. This training will consist of a video replay of training on this topic previously presented by the Prosecuting Attorney's Council of Georgia. The court will provide the video, and the viewing will occur under the direction of the court. This entire motion boils down to the prosecutors have to watch a training video on Brady violations. So ordered by Judge Paige Reese Whitaker. Wow. I will say this, having heard Judge Whitaker on the bench in the Young Thug trial as this has continued, this filing that she's made does not do it justice. This just boil it down to, hey, you have to watch the video again, guys, because you did bad. Watch the training video, and then you'll be good. It doesn't do it justice. I think she actually has laid down the law. And although she has given them one more free pass at some of these issues, I don't think they will get any of those in the future. I think we might see near to the end of the bad behavior when it comes to Brady violations by the prosecutors. But back to continuing education credits for the prosecution team. But that is hilarious. They have to watch it in court. The judges can make them sit there and watch it. And it's like, pay attention, Prosecutor Love. Prosecutor Love, eyes up here, please, on the screen. Do you want me to rewind this for you? Yeah. So that's gonna be funny. I cannot wait. That is great. All right. Let's see. 3. Let me see what this. Not even the naughty step. Nope, no naughty step. Brady training. If you have the slightest inkling that there has been or could be Brady, please tell me You have no other option but mistrial. Matthew Harris, I need you. Yeah, Brady violation is bad. And she, in this finding, I think she's tiptoeing through. This finding will probably make it to appellate courts if there's a conviction in this case. I think this ruling on the Brady issue and the other Brady issues that led up to this are definitely going to be a subject of appeal. And yeah, I didn't like the way the judge picked and chose her way through to say, yes, technically, but was not willful. I don't care. You've got an obligation. And yeah. Anyway, movie night in Young Thug. Last time we watched a movie Young Thug that wasn't expected to be played, it resulted in me deleting the video. It was a Brady lapse. Brady lapse. We should all watch it together. Permit means to ignore or purposely disregard something. Or preterm it. Hey Siri, define preterm it.
Pretermit is an archaic term. It means omit to do or mention. Do you want to hear the remaining one?
Yes.
Pretermit is an archaic term. It means abandon a custom or continuous action for a time.
So Melanie, you're 100% right. But let me just say, the first thing that Siri said, and she said it twice, pretermit is an archaic term. If it's archaic, probably don't use it. Okay, because most of us are not archaic. All right, there's another update from Judge Boyd from about 25 minutes ago, 4 minutes long. We watched that one, I think. Let's see what we have with Judge Boyd. Pretty sure we watched this last one. She comes in at 2:49. There she is. Wasn't this the one where they had more questions? And she basically said, you have all the law in front of you.
All right, we're back on the record in 2022, CR 11862, State versus Alexander Castro. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas. Daniel Escobar and J.C. Garahan.
Yeah, we watched this one.
For the defense?
We watched this one.
For Mr. Castro.
I remember because the
And
lawyer
Mr.
messed
Castro
up
is
his name
present?
then
Yes,
too.
yes, Judge.
The court has received the following questions from the jury. First question, is there the option to continue
Yeah, we watched. Is there an option to continue? I'm in mission control mode. I've got all the views. Tell you how I've got it set up right now. We have 8 feeds going into the switcher, which as long as I don't touch things, most things work. My button machine is not working, but this particular screen right here, I only have 2 screens. Normally I have more screens than that. So, well, I say 2. I've got 2 here, and then I have the 2 laptops. This one is running I'm using that instead of the buttons. It can do everything this can do. It's just, this is easier. I just have to get that working. But this screen is the one that I can look at and look like I'm sort of looking at the camera instead of like staring off into space, which makes me just look like a goofball. So I can put anything I want. Any of my 8 screens I can put up on there. So I can put me, I can put, whatever's on channel 2, channel 3, which is chat right now. But chat, this is also the channel I bring in the intro video on. So I could swipe over on channel 3 and I could play the intro video right there. Channel 4. Channel 4 is the GoPro behind me. Channel 5, that's our Blackmagic Cloud Dock. Channel 6 is the second monitor from my laptop that's running the switcher. Channel 7 is my pan-tilt zoom camera, which I'm watching the mountains to see if we can see them. The wind is supposed to be blowing this smoke away. So I can watch out the window. Oh, look, people are playing in the park. Isn't that nice? I think there's like a football game. Let's see who's out here. Oops. I see either tennis. Yeah, there's tennis and pickleball. Oh, there's a puppy. You guys see the puppy? We're going to zoom in on the puppy. Who's a good dog? Trying to focus. It looks like a border collie. But anyway, that's channel 7. Then we have channel 8, which is another, that was Judge Boyd's. And then of course I've got like Super Source and things like that, some other things, media players that I can show as well. And I can also make it be another multi-screen up there, but that's how I have it set up right now. We just see your back. It's sort of a weird view. I haven't got a good place for that. I like you guys to be able to see what I'm dealing with, because that way when I make a mistake, it's like, look how hard this is, right? This is my plausible deniability. It's like, it's not my fault. I couldn't. Anyway, Welsh Lady reads, I only have this one screen in front of me. Also, all right, here's the switch that controls all 8 of my screens. Yes. You stopped cleaning because you said puppy. I'm watching. Oh, look, look at this. Dog's being pet. Just enjoying some shade time. I'm jealous. That's like a quarter mile away, by the way. That's way out there through the window. I feel like a creep spying on people outside in the park. All right. Let's see. The Boyd jury either have a luxury hotel to sequester in, or they're finding new love interests amongst their tribe. Let's see. Thanks, Welsh Lady. I appreciate that. I think it's a 30 power zoom. I think that camera has 30 power. Probably more than we'll ever use in court, because that's a super close up. But when the time comes, it could be useful. Let's see, is Weather Watch here? What's going on in PA and New York? I heard they had like tornado warnings and just crazy storm. Flooding. It's the remnants of the, what it is, it's the remnants of the hurricane that came through Florida, went off the coast, landed again in South Carolina, went up the East Coast. Temperature here is just below 90. I think I heard a car door close. That might be my family coming back. Yes, how many subscribers does Weather Watch have? I'm just asking for a friend. Oh, he's got 1,250. I think he needs to make another video. Oh, there he is. Hey, Weather Watch. Massive floods in PA. They're calling for more air and boat support. Oh, my goodness. I just heard something bang in the house. So I think it's my family. Yeah, I think it is. Not enough subs, in my opinion. Yes, please give Weather Watch a follow. He is my podcast partner. He doesn't do a ton on his channel, but what he does is great. He's a great weather guy. He's a weather nerd. I think I can safely call him that. Loves the weather that frequently sweeps up across his parts and other parts of the country, and he's great at keeping us informed. Plus, he's just an amazing guy. If you get to know him, this guy is just incredible. He's a friend to everybody he meets, unless they prove otherwise. So. Missed your door chime. I missed the door chime as well. I'm tempted to have one installed. That's actually my home security system that does the door chime. That's a feature we turn on. But it's really bad up here in PA. It's the FBI. Open up. They found me. He needs to do one for every day he hasn't streamed. Weather Watch says yes. It's really bad. All right, where are we in court as far as what we're watching? Judge Boyd still, possible verdict. The questions the jury asked, can we work the weekend? That does not give me hope that they're about to reach a conclusion. It seems that they have a lot of points of disagreement, not just on the facts of the case as far as, was there a prior arrest, things like that, but how the law is supposed to be applied, and then you can't get to the actual application of the law until you've established those other things. I think they have a lot of work to do. So I'm thinking a Monday verdict is probably on tap for Judge Boyd's case, unless just by miracle they come together and say, look, enough is enough. Let's just reach a conclusion. I don't like compromise conclusions, though. Let's see. I heard somebody sneeze. I think that's my kid. Just signed up to subscribe to Weather Watch. You won't regret it. You won't. He's a good guy. Love and prayers for me to PA. Yes, please stay safe, all of you. That is crazy. My part of North Carolina had 7 inches of rain yesterday. For people who are specifically out west, 7 inches of rain it blows your mind. You might be in a place that gets like 18 inches of rain a year or 22 inches of rain a year, and to imagine getting a third of the year's rain in a day. It's bizarre. You can't fathom it until you've actually seen it come down like that. And it's like, wow, there's raindrops falling, but there's more rain in the air than there is air in the air. Does that make sense? Like the gaps between droplets are smaller than the droplets themselves. It comes down in buckets, and unless you've experienced it, it's bizarre. But love it. Love all the weather things. Please stay safe though. It's the trees in North Carolina. They come down and they cause havoc. They do. And they come down because they get so much water that the roots don't have to dig deep. And then when a storm comes through, it just tips the whole thing over. Let's see. Central New Jersey, tornado watch until 10 p.m. Rallo, tornado chaser as well. Hey, from Missouri. Awesome. We're trying to figure out our route back across the United States when we go back home to North Carolina. We want to hit a few other states, but we did go through St. Louis, and the arch was probably one of the most impressive things I've seen on this entire trip. And I've seen a gigantic pitchfork with a handle the size of a telephone pole. I've seen a golf tee that was like 30 feet tall. I've seen some pretty cool things, but the St. Louis arch, that just impressed me. Torrential downpour now. It's moving slowly, but it is moving out. I totally got out of North Carolina before the storms. I did. And unfortunately, I don't know. I'm hoping, fingers crossed, that everything is working there. If there's a problem, I don't know what to do. You should go up in the arch. You can go up in the arch? Please tell me it's not stairs. It has to be an elevator. Have you never seen an elephant fly? Or an elephant fly? I've seen a horse fly. Does that count? All right, looking at court, I think it's Friday. I think we're about to be done. Let's see here. Where else do we have? I have to watch Luke McFadden's latest video about the boat he bought getting vandalized the night he bought it, which is terrible. Let's see. We've got Karen Reed done. We've done the Corey Richens. We had a state execution in Utah the other day. That was interesting. Lethal injection. I think we're good. Any fun weekend plans? No, but I am going to hang out with my family this afternoon. It's 2 p.m. here, but it's 4 p.m. Eastern time, so it's a little bit earlier than we normally end it for the day, but it is a Friday, so the arch isn't as big a deal as it seems. The museum underneath is better. Take motion sickness meds if you travel up the arch. It's sketchy. Okay, you just convinced me, Christy. I'm not going up. I got so motion sick when I went out on the ocean. Of course, it was deep sea fishing, and there was some pretty impressive swells. But a lot of rain in NC, but that's basically it. The main worry was down trees and some area flooding. There was a good police chase. A couple. I think there were 3 yesterday, but I'm not prepared to show any of those right now. I am going to go play with the family. They're here. We're going to wrap up here in just a minute. All right. I think we are there. Let's do that. All right. As we wrap things up tonight when you go home, please please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow. No. Tomorrow is Saturday. I thought today was Saturday. Tomorrow is actually Saturday. Anthony B., you're in Farmville? You're in Farmville. I go to Farmville all the time. That is crazy. I've got my business partner lives in Farmville. You probably know him. It's crazy. It's a small world. All right, tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. Please stay safe till we go live again Monday morning or possibly earlier if Judge Boyd's jury comes back with a verdict. We'd like to bring that to you. So we will do that. Let's see, Olympics, the girls breakdancing. Sounds cool. I'm going to enjoy my vacation this weekend. Yes. Thank you all. I appreciate all the kind words. Please stay safe. A lot of bad weather out there. A lot of crazy people on the roads. Whatever you're doing, please stay safe. I'll see you back on Monday. Have a great weekend. Have a fantastic weekend. Wedding planning, yes, it's in full swing. Thank you all. Thanks to the great mods who helped make things awesome. Thanks to our great internet winners who kept things running perfectly for us. And thank you all to all of you who make this channel possible and make it what it is. I wouldn't be the same without you. Thank you so much. You guys have a great evening. We'll see you on Monday. Bye-bye.